I hope everybody had a safe fiesta. Oh, yeah. Well, I was with my mom in Louisiana and with my niece, who is 3, but has the confidence, the self-esteem, and the wherewithal to tell you what she's feeling in a very, I don't want to say aggressive, but very demanding way. Yeah, but no, she's extremely nice. Yeah. Well, it's always good to see her because you sort of get to see the world in a new way because you're seeing it through her eyes. So that's always great. Yeah. Although she loves her baby Finn. I know every song. All right, everyone, it is 9:00. I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Christian Reyes Garcia. Thank you. Luis Rivera. Thank you. Carrie Lampkin. Thank you. Mary Guerrero. Mary Stella Guerrero. GMO Altimarino. Alexander Aguilar, Mason, Washington, custody. Matthew Moran. Matthew Tyler Moran. Constance Sinil, custody. Juan Aguilar. Juan Andress Aguilar. Thank you. Ezekiel Chavez, custody. Mason, Washington, custody. Isaiah Story. Isaiah Nathaniel Story. Luis Rivera, custody. Jesus Zamaripa. Thank you. Mitchell Moore. Mitchell Claire Moore. Jose Romero. Thank you. Tomminique Grant. Jodie Flores. Christopher Bernal. Thank you. Isidro Garcia. Eddie Outlaw. Okay, I like your name. It's Eddie Law Outlaw. Thank you. Matthew Griss. Robert. Somebody help me with the last name. I'm sorry, pronounce it. Medeiros. Robert Medeiros. Thank you. Look, he wasn't here to see me struggle. Glenn White, custody. Renee Gomez. Anthony Villarreal. Daniel Berlanga. Julian Gonzalez. Kevin Deloo. Thank you. Jose Mahia. Oscar Jimenez. Carrie Lampkin. Thank you. Kenneth Howie. Daniel Berlanga. Arturo Villanueva. Arturo Villanueva. Abel Favala. Let's see. Rakeem Asmore. Daniel Morales. Custody. Joanna Reyes. Thank you. Alexander Rangel. Alexander Rangel. Camillus Galvan. All right. Is there anyone who's present and your name was not called or you came in late? All right, everyone, these are the rules, and I'm going to. Yes, who's raising your hand?
We're ready, PSI, restitution. Your Honor.
What's the name?
Dylan Thomas, T-A-M-E-Z. I'm sorry, Red.
Randy. Okay. All right, if you all can make sure I have that file.
Yes.
All right, once we get the file, just approach and I'll take you up. All right, everyone, I'm gonna repeat the rules because I've been away. People had fiestas. Sometimes when fiesta happens, because of what happened during fiestas, memories tend to lapse. So these are the rules. Number one, we're recessing at noon so the staff can have their break. The criminal trial division files are here. Family violence files are there. Attorneys, just pull your file, have a seat, place it on the prosecutor's desk. They'll call you in the order of appearance. Once you've conferred with your client, conferred with the state, and you're ready to approach the court, just approach over here, ask the clerk to pull your file, have a seat. I'll call you in the order of appearance. If your client wishes to speak to the court in a language other than English, we'll need an interpreter brought down. Just let the clerk know you need an interpreter for this file. Once you've requested your inmate from the deputy, do not leave the courtroom. For security reasons, there are only so many inmates that are allowed in the box at one time. If you request an inmate and leave, you're being selfish to your co-counsels and to your colleagues because their inmate won't be able to be brought out. Once you've requested an interpreter, do not leave. We have a limited number of interpreters. Interpreters usually get here in 5 minutes and they're only here for 10 minutes, then they need to go to another court. Do not talk behind the court reporter while we are on the record. How you know we're on record is because I will have called the style of the case. Just raise your hand. The deputy will move you and your client to the other end and you can talk down there. Please remember the whisper. We have probation officer here. Ms. Abrams, can you raise your hand? She's an integral part of this system. If you have someone who you think is going to get probation or someone who's on probation and there's a motion to revoke to be heard, confer with her. That will make the process move along quickly because guess what? I'm going to ask her what her thoughts are and opinions are on the case anyway. So today is Monday. We thought fiesta would last forever. It doesn't. It is over. So we are not retired. We're just going to have to deal with that fact. We're going to put some smiles on our face because it's Monday. It's a new day. The sun is not out. Looks like it's going to rain. Maybe not. Who knows? But we're going to enjoy today. So please confer with kindness and everyone, let's have a good day.
Jodie Flores. Yes, we're gonna flash drive and then, I'll get everything done.
Glenn Lorenzo White. Hello.
Morning, Judge.
Good morning. Where's your client?
He's in custody.
Oh, they have to have him brought out.
Okay.
All right, thank you.
I
you need to request
was gonna request a reset.
All right, you need to request him from the deputy. And have you conferred with the state?
Yes, ma'am.
All right, so just request him to be brought out. And then once he's brought out, just approach and have them pull the file and I'll take it up. All right. All right, so I need the trial court certification. Counsel on Chavez. I'm gonna need a trial court certification that they're printing it out.
I'm confident I did it already, but I'll do it again if you want me to.
All right, yes, because I don't have it here. Oh, Mr. Callahan, she's doing it. She's printing
All
out.
right,
something.
thank you.
And do we know, is there restitution in this case?
Oh, that's the point of being reset. We have a plea agreement. Judge Angelini wanted a restitution figure, which was not available last time.
And it is not available this time.
And maybe,
because-
pardon me,
That's okay.
Mhm.
The owners of the vehicles that Mr. Thomas struck
Mhm.
as a result of the offense were
Mhm.
not listed as witnesses within the offense report, so I needed to go through the crash reports, which did not include contact information, so I needed to ask our investigator to look up their contact information, which I now have, but I have not had an opportunity to attempt to contact them yet.
Okay.
may I address the court?
Mhm.
I suggest that you assess the plea agreement and let probation office calculate restitution, if any. My belief is that there was insurance, so at best, from my point of view, he would owe premium payments on the insurance, but I don't know that for sure.
All right. So you want to ask your client if he had insurance?
Yes, ma'am.
All right. And then we'll take the matter up. All right. Do y'all have the trial court certification for Mr. Callahan? All right, thank you.
See how some of this. Jodie Flores. Along with Docket. Good morning, Judge. How are you?
Good morning.
Judge, I apologize. I wasn't here last time. I was sick.
Oh, no.
And then whenever the court reset it reset on the last Friday, that CLE. So
Okay. Oh, no problem.
Apologize for not.
Oh, no problem. Thank you.
Yes, ma'am. Thank you. May I address the court?
Yes.
Paperwork can be produced by the probation office or yourself. If you in about 2 days. I suggest with the agreement of the prosecution that you assess the probation.
Okay, all right, let's bring him forward. All right, court is calling 2025 CR 002829, State versus Randy Romero Thomas. Could I have parties announced for the record? State,
Denny Callahan defense.
and are you Mr. Thomas?
Yes, Your Honor.
All right, you entered a plea with Judge Angelini. Do you have any objections to the court sentencing you?
No, Your Honor.
All right, according to your plea bargain agreement, punishment was to be assessed at 6 years in the prison. The state is recommending community supervision. Are you currently employed?
Yes, Your Honor.
What do you do?
Hospitality, Your Honor.
I'm sorry, what?
I'm in hospitality, Your Honor.
Ah, okay. What part of hospitality? What do you do?
Food and beverage.
Okay. And when you say food and beverage, is this alcohol?
Yes, Your Honor.
Where do you, are you at a bar? Where do you work?
I work at the Pullman Market. It's a restaurant called Mesquite. I'm a bartender.
All right, so that may be a little bit difficult for you
Yes,
because of the nature of this offense. So you may want to look for other employment. I am not going to tell you can't work there, but you can't drink while you're on probation. Do you understand?
Yes, Your Honor.
Is there any objections to his working at this bar?
But we just ask for operations to monitor consumption of alcohol.
All right. Are you currently on ignition interlock?
No, Your Honor.
What are you on?
Scram.
All right. Do you have a vehicle or was your vehicle totaled?
I do not have a vehicle. I have no vehicles in my ownership,
Whose
Your Honor.
vehicle was it?
It was my girlfriend's vehicle.
All right. Who do you live with?
My girlfriend.
Does she have access to a vehicle?
She does, Your Honor.
All right. So any vehicles that are at that home are going to have ignition interlock on the vehicle.
Yes, Your Honor.
All right. The court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs, a TAP evaluation out of custody, follow all TAP recommendations, 120 sober meetings in 120 days, proof of employment within 30 days. There's to be no employment as a home health care provider with minors, 2-year license suspensions, VIP live, DWI intervention, DWI education, 200 hours of community service restitution. Do you have any children?
Yes, Your Honor.
How old are they?
3 months old, Your Honor. 4 months old yesterday, Your Honor.
All right. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. I'm sorry, state your excuse.
Oh, thank you.
Thank you. Field visits 1 time per month for 6 months. There's supposed to be a 10-day Bexar County jail sanction. You have a choice. You can either do the 10 days in the Bexar County jail that will start today, or what I will do is I will sentence you to 20 days on GPS. It'll be partial for employment only.
Yes, Your Honor.
What do you choose?
The second one, Your Honor.
All right, there'll be 20 days GPS, partial for employment. Now, are you able to afford the GPS?
Yes, Your Honor.
Okay. There is to be a referral to felony drug court. Probation is, one other thing, there's to be restitution, if any, to Diane Ness, Ness, and Amy Hall. And we're going to set this for a restitution hearing. State, you'll need to have information on that restitution. We're going to set it for a restitution hearing on May 19th. Is that enough time for you? All right, we'll have a restitution hearing on May 19th.
May I address the court?
Yes,
You need the defendant there for that hearing.
yes. Probation, is there anything else he needs? Oh, I am so sorry. Ignition interlock for half the term. And that's to be on all vehicles at residence.
I have
install date for his, GPS.
How much time will you need?
He Dutch?
Yes, how much time?
Oh,
All right, so the ignition interlock needs to be installed no later than May 12th.
I'm sorry, Judge, that was for GPS.
Oh, I'm sorry, GPS, May 12th. Thank you. Hey, I'm starting over. All right, so that GPS needs to be installed no later than May 12th by 4 p.m. All right, is there anything else you need from the court in order to be successful on this probation?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, Your Honor.
All right, we can go off the record. Here's the thing, you have a 3-month-old, right?
Mhm.
All right. People always think that they're sober when they're not sober. I have yet, and I think your attorney will tell you, he probably hasn't had it either. There has not been a single case I've seen where someone ends up killing somebody driving intoxicated, where they said, my intent was to go out, get drunk, get in a wreck and kill somebody or injure somebody. You are one of those people who cannot drink alcohol. You know why? Because you don't know when you've had enough. You can't drink just one drink and be done.
Yes, Your Honor.
The way this vehicle hit other vehicles, guess what? You say you have a 3-month-old, there could be somebody intoxicated driving around, end up hitting your 3-month-old while they're in a vehicle. I don't think you would want that, and you would be upset about it. So from here on out, everything that you do, you need to be doing it so that your child would be proud to say, that's my father. You understand?
Yes, Your Honor.
If you have an issue with drinking and you think you're going to take a drink, you need to call your sponsor. If there is something on probation that you're struggling with, call your probation officer. If you feel they're not addressing it, you can come back to court. You understand?
Yes, sir.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Ask you a quick question.
Sure.
I was gonna put my file on there, but the state and I would like to talk to you for a few minutes about our case.
Sure.
If you have a minute, Judge.
All right, just give me a moment.
Yes.
Who's here on Glenn White? All right, Mr. White, come forward. Hello, Mr. White. How are you doing?
All right.
All right. So on this case, where are we on discovery?
Defense counsel indicated to me that he was unable to get what's on discovery, so he's gonna provide our office with a flash drive, and I'm going to make sure and get it downloaded and provided to him so he can review discovery. I'll provide that to him tomorrow, Judge.
All right. So Ms. Ferguson, recall this at the end of the month for discovery.
Yes, ma'am.
All right, we'll come back on May 29th for discovery. Do
Thank
you
you.
have any questions, sir?
No.
All right, we'll see you back on May 29th.
Thank you, Judge.
You're welcome. Bernal? Who is this?
I don't know if it's what function.
What's the name?
Your Honor, I have that setting for today, but it's not set today, so that's what I'm inquiring about.
Okay, I don't know.
Okay, I'm sorry.
Yeah.
Everybody come in, they have to log in.
All right, Mason, Washington. Oh, is this your case? Yes. Oh. So once you all hand that to me, I said, once you all hand that to me, I'll take it up.
If we could just also tell you a couple of reasons. why.
Sure.
I'm just waiting on. Mr.
All right, so
Ross.
once they're ready, let me know. Who's here on Joanna Reyes? All right, the court is calling 2018 CR 13404W State versus Joanna Reyes. Can I have parties announced for the record for the state?
Casey Garahan, Your Honor.
Defense?
Stephen Gilmore from Ms. Reyes.
All right, and are you Joanna Reyes?
Yes, ma'am. Fire in the courtroom.
All right, this is a case where she entered a plea on December 18, 2018 of guilty
Yes, Your Honor.
and applied for deferred adjudication. And let me see the attached plea bargain agreement, which is not attached. Let me see if I can find what your plea is.
Sorry, Judge, I don't have a copy of it, but I know there was one in the file. Seen it.
All right, let me see. All right, we can go off the record. If y'all want to see if you can find it in here somewhere.
The judge, I mean, it may not be in there, but
But I think Cindy may have a copy of it.
if she doesn't, I can probably go upstairs
Sure.
and grab one.
All
So
right.
I'll take a look at this if you.
All right, thank you. Thank you. It didn't have the plea bargain agreement attached. Who's here on Matthew Tyler Moran?
President, Your Honor. He should be on Zoom.
He is. And who's the prosecutor? Hi,
Good morning, Judge.
good morning.
Oh, wow, that's how I look like. I told you.
Oh,
Told you, Joey.
Nah. All right, so we're here for an offer is due and also discovery.
Yes, Your Honor, there's one more piece of discovery that I need to upload or ensure that it has been uploaded, and I have tendered an offer to defense.
Okay. And when will that be uploaded?
I can get that done later today.
All right, other than that, is there any other discovery?
No, Your Honor, just for the record, the only thing we're missing right now is the video interview of the complaining witness.
Mhm.
And that's what's lacking at the moment.
Okay. All right, Ms. Ferguson, put this for a plea deadline date, the beginning of June. All right, June 3rd is your plea deadline date. If an agreement is not reached by that time, your next court date is going to be a jury trial setting. The court will not accept any plea bargain agreements after June 3rd without good cause. Otherwise, you have to enter a plea open to the court. You understand?
Yes, ma'am.
All right, thank you. And thank you for dressing appropriately for court. You're
Yes, ma'am.
Thank you.
Excuse.
Yes. And Norma, he can appear by Zoom for that. Yes.
I'm gonna run upstairs and grab it.
All right, thank you.
I'm dismissed as well, ma'am.
Yes, you're excused. Thank you.
Yes, ma'am.
Yeah, I'll go grab it. We have copies.
You're good.
Your Honor.
Yes. Sure. Oh, I thought y'all wanted to.
Yes.
Okay. All right, I'll be back in 5 minutes.
I haven't.
At some point this morning.
Approach briefly.
Sure.
I'm here on Alexander Aguilar, and we reset it to this date to see if the DNA was back.
Mhm.
He's not sure.
Well, part of it isn't. At the last setting, we didn't have the scene report from the victim yet. That did come back in between. Since then, they also obtained a search warrant for the defendant for a buccal swab from him. And that's what is still pending, is to see did the
Is he in
lab
custody?
test.
Yes,
All right, has it been brought up?
I don't know.
not yet.
All right, haven't brought up.
Okay.
Thank you. All right, who's here on Christopher Bernal?
Present, Your Honor. What else for now? Do you have them on the docket there?
Yes.
These are various cases that are going on.
All right, let me.
So Judge, last setting,
Mhm.
I was appointed onto the case, took over for another attorney.
Yes.
I've looked at the discovery on the UUMV case.
Mhm.
However, there is, and I need to continue it to talk to family violence, but
Mhm.
there's a continuous violence case that has not been indicted.
Mhm.
So I need to talk to them, coordinate with them. Hopefully we can work out something to everybody's liking.
All right, so what date are you asking for?
I do want to do a short 2-week reset to the
Okay.
week of May 19th. This way, he's not lingering too long in custody.
All right, Ms. Ferguson, May 19th on Christopher Bernal. All right, do you have any questions, sir?
No, ma'am.
All right, we'll see you back on May 19th.
Thank you, Your Honor.
Thank
You're
you, Judge.
welcome. Yes, you can put discovery. And Mr. DeLeon, are you on the continuance violence case? If you can make sure you're on that case as well.
Double check on it.
All right, thank you.
Judge, I just have the one case from Mr. Bernal, and then is that a reset as well?
Yes, it's May 19th,
Thanks.
sure. And it's the same Christopher Bernal, is that correct?
I believe so. Judge.
Norman, make sure that's the same Christopher Bernal for him.
We have an agreement. So I think we can do it.
Kenneth Deloo. We're dressing appropriately for court. All right. All right, so where are we on this case?
Yes, Your Honor. So the state has made an offer today.
Okay.
We need to speak with the misdemeanor attorney because they're trying to do I guess, a global deal. So we're asking for a reset. In addition, Your Honor, I had filed, previously we were here, there was a GPS violation hearing in which the court, he was on partial GPS house arrest for work. Because court had restricted him to house arrest. I filed a modification of that. I have my client and I have both provided his probation officer proof of his employment, and they verified that employment. So we're asking for the GPS conditions to be modified again to partial house arrest. Unfortunately, since the previous modification, he is really struggling financially, not able to work, and is close to losing his current living conditions.
So it's the court's understanding, and if I'm wrong, correct me, because usually I don't do full house arrest unless there's a reason for it. So I'm assuming there was a VR
Yes, Your Honor.
violation report, and he was
Yes.
violating GPS?
He was, Your Honor. I think the issue was at that hearing, the probation officer was unable to actually come and testify. So we couldn't really get into a lot of the violations at that point, but there were allegations that he did violate some of those in the times that he was supposed to be away from. It wasn't that he was getting close to the complainant, because there is no harmful and injurious contact. It was that some of the locations that he was going to were not related. Well, probation believed they were not related to work. It was actually him going to seek additional work at different barber shops.
Mhm. All right, you'll need to set that for a hearing, get a hearing date from Ms. Ferguson. This is coming back for a plea deadline date on May 19th. Ms. Ferguson, give them a reset for May 19th and then set their motion to modify bond condition as soon as possible. All right, thank you. Once you sign the reset form, you're excused. Who's here on Jose Romero?
Is it all right if he sits there, Judge?
Sure.
His competency issue.
All right, so where are we?
Yes, Judge. On Thursday, May 1st, in Magistrate Court, he was deemed incompetent by Judge Rodriguez. He was deemed eligible for outpatient competency restoration services with the Center for Healthcare Services. They're going to be picking him up on Wednesday and transferring him to a boarding house where he can also undergo that treatment with Center for Healthcare Services. We're requesting some time on this case, Judge, being that he's going to be working that program to see about getting restored to competency. So we're just requesting a reset out for status on this one.
All right, we'll recall it for June 23rd.
Yes, Your Honor. And
We'll just see where we are, and if you have information where he is, and if he hasn't regained competency, just come in before that date and we'll give another date.
Oh, great, Your Honor. Yes, really well, I appreciate that.
All right, thank you. Norma Jose Romero's June 23rd. Yes. On Washington, they should give me the stipulations. Oh, yeah, I think they have it. Yeah. Mary Stella Guerrero. Isaiah Story. Mitchell Moore. Where's Mitchell Moore? Oh, just have a seat. All right, he was late. Robert Medeiros. He's here? All right. Do y'all have the steps on Washington? Family violence, do you have the steps on Washington? Thank you. Yes,
Judge, I don't know if you already have Mr. Flores' file, but I was just gonna add that to his.
sure.
um,
No, they haven't given me
Oh,
Flores
okay.
this file yet.
We have a plea bargain this morning. I just wanted to give the court those a little bit early.
All right, thank you.
Thank you, Judge.
Yes. I just had the plea bargain agreement, but no steps.
You want me to go make a copy?
Oh, no, it's fine. Let me see.
And that's just the agreement that was signed.
All right, thank you. All right, thank you. Oh, could I see the file on Reyes, please? Yes. All right, court is calling 2018 CR 13404W State versus Joanne Marie Reyes. Could I have parties announced for the record?
Jason Garahan for the state, Your Honor.
Stephen Gilmore for Ms. Reyes.
And are you Miss Reyes?
Yes, ma'am.
All right, so you entered into a plea bargain agreement with the state on December 18th, 2018. According to the plea, you entered a plea of guilty. The state is recommending deferred adjudication. And according to the plea bargain agreement, the state is recommending 10 years deferred adjudication. They will dismiss 2 other cases. And it states here that they will adjust the recommended time of deferred adjudication to 8 years instead of 10 years of deferred adjudication if you spend 2 years without violating bond conditions. So that's the plea bargain agreement. Is there, yes.
Sorry to interrupt, but I believe that the way I read it, and I know it's a little confusing, but it's put down, I don't know who wrote that, but I think that the amount of time that she spent on bond for the case would be taken off of the 10 years. And then, for instance, if she did 2 years on bond, we would reduce it to 8.
Okay.
So I believe in this case.
All right, somebody who did this plea bargain agreement, I know it wasn't you, but they didn't take or pay any attention to contracts in law
Had to
school.
read it a couple times myself.
All right, yes.
So, and I believe that I believe it's 8 years that she's spent on bond on this
Mhm.
particular case, Your Honor.
All right. So the court will hear whatever evidence either side wishes to present.
Well, the state's position with the actual plea bargain agreement that was entered back in 2018, that she's been on bond total, I believe, 8 years. So the state would be recommending 2 years deferred adjudication this time.
All right,
That's also what defense is requesting, Judge. She's performed under the contract. She provided truthful testimony in the trial of a cause that happened just a few weeks ago in a capital murder trial. She was available for sentencing as well if needed. For the reasons that she has performed under the contract, I just asked the court to continue following the plea bargain agreement. She's also executed a declaration under penalty of perjury that I've discussed with Mr. Garahan, that she is presently indigent for purposes of fines, costs, and fees associated with probation, but principally, Judge, when she had the other case that was pending, and I believe everything has already been dismissed, there's nothing to be tested at this time. But in one of the cases that was pending, she had a GPS monitor, and Judge Contreras did not, I don't know why he didn't, but didn't waive the fees. And so she has a balance on this case. Whenever she reports to pretrial, there's a balance for GPS fees. I would just ask the court to waive the balance of the GPS fee.
All right, I can say waive balance of GPS fees, but if it's a third-party contract, I have no authority or the jurisdiction to force them to waive GPS fees.
Of course.
All right, anything else?
Nothing further, Judge.
All right, Joanna, raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? Oh, help you God.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Joanna Reyes.
All right, are you currently employed?
Yes, ma'am.
What do you do?
I am a hairstylist and I work for Amazon.
All right. And how long have you been doing that?
For hairstylist, about 7 years. Amazon, I just started about 6 months ago.
All right, and do you have any children?
No, ma'am.
All right. So how are you supporting yourself?
By working.
All right. And the reason why I asked that is because your attorney said that you can't pay any fees. So do you live by yourself?
Yes, ma'am.
All right. And you say you're in school?
Yes, ma'am.
What are you studying?
I'm getting a cross Cosmo, so I can do barber, and I did just open my own salon in December, so it's just for the licensing and everything.
All right. And how old were you when this offense was committed?
I believe I was 19.
Okay. All right, anything else?
Nothing from the state, Your Honor.
All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. Proof of employment within the 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Field visits 1 time per month for 6 months. Probation, is there any classes that she needs? All right, thank you. TAP evaluation, follow all recommendations. There should be 200 hours of community service restitution. Probation, is there anything else? All right. And of course, there's to be no contact with the co-defendants. All right, is there anything else you need from the court to be successful?
No, ma'am, thank you.
All right. And if I didn't say it, 200 hours community service restitution. Is there anything else, defense? And did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, we may need to change this because this documentation has changed.
Sure.
Yeah. Could you print them out a trial court certification on this case? No. It's just that this one is an old one from 2018. Yes. I want to say it's Jalen Bell and Tamar McIntyre. And is there any victim impact in this?
No.
All right, state, you may be excused. I'm just gonna wait for this trial court certification. Thank you.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. To be successful on probation in this court, communication is key. If you have an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court. All right, and if you completed any type of educational courses where you obtain a certificate, just give it to probation and I'll consider waiving some of the community service hours. I just need to know what it is.
I never got my property out when I was incarcerated, but I did several classes when I was incarcerated with several certificates, so I'm not sure if I'm able to obtain them still.
All right. Yes. All right, so just speak with probation and then you'll be excused. Thank you.
ma'am.
And thank you for dressing appropriately for court.
Thank you so much.
Oh, no problem.
Alex.
Address. Very deep.
Alexander Aguilar.
You want him up here, Judge?
Yes. Right, so. Oh. Just one moment. Obviously, it's a little bit slow. Mhm. All right, so where are we on lab results?
So we got the lab results in for the victim's same exam. We need to have the defendant's buccal swab taken and sent to the lab to compare to the DNA that was found in the same report. There has been a warrant signed to that effect, but it hasn't been properly executed. So I need to have SAPD sent down to the jail today so that they can take the swab of the defendant and have that specimen sent to the lab for testing.
All right. And you know, maybe this is just me, and I know it's not your fault. I don't understand why cases are being indicted and DNA is not done. And then we wait to, I say we, but I don't mean me. Then there's a wait to, now let's get his DNA and see if it compares to whatever other DNA. I don't understand that.
Agree with
All right. So that's probably going to take, what,
you.
8 months?
Just early, I can put a rush request on it and hopefully have it done within the next few weeks.
All right. So we have that. CPS records, you have already exchanged those?
I believe we have it.
Believe so.
Okay, so it's just the DNA that we're tracking.
All right, Ms. Ferguson, if you can recall this for the end of June.
We're just a status hearing.
It will be for discovery, and that will be the final discovery hearing.
Yes, sir.
All right, June 26th.
Thank you.
Any other questions?
No,
All right, thank you.
it's funny. I've never heard anybody complain about honesty.
Who's here on Juan Andress Aguilar?
Judge.
Good morning. How's it going?
Go well yourself.
Oh, I cannot complain.
Virtual pickup,
Yes.
signature methods. Thank you, Your Honor.
Thank you. All right, where are we on discovery?
Disclosed the CPS records that defense was requesting today,
Okay.
and he signed the, receiving, Your Honor signed the order of protection. So I believe all discovery matters are now complete.
That's correct, Judge. I would just need time to review those CPS records and ultimately.
All right, how much time are you asking for, counsel?
Judge, if you can maybe give me 30 to 45 days, I think that should be sufficient.
All right, Ms. Ferguson, I need a date for the end of June. It's a plea deadline date. All right, June 26th is your plea deadline date. You'll need to let the court know whether or not you've reached an agreement with the state at that time. If you have not reached an agreement, your next court date will be a jury trial setting, and the court will not consider any plea bargain agreements without good cause. You understand?
Yes, Your Honor.
All right, thank you. Thank you for dressing appropriately for court.
Thank you, Your Honor.
You're welcome. Once you sign the reset form, you excuse.
Thanks, Judge.
You're welcome.
Garcia, maybe the real estate.
All right. Jodie Flores, sorry. Court is calling 2025 CR 001919 State versus Jodie Flores. Could I have parties announced for the record?
Andrew Harrison with the state.
Sean Simpson for Mr. Flores.
And are you Mr. Flores?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review with your client?
I have your.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Judge. It's not.
All right. Mr. Flores, did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Flores, did you review the court admonishments with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charge of possession of a controlled substance, penalty group 2, less than 1 gram?
Yes, Your Honor.
As a state jail felony, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge. Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I do.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 200 days in the Bexar County Jail under 1244. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No motion.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State Office Exhibit 1 and attachments, Judge.
No objections, Your Honor.
State, you may be excused.
Thank you, Judge.
Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. The court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No, Your Honor. Judge, I take that back. I would like to just, for the record, note all of the courses that he has completed that I have turned over to the court.
All right. And the court has reviewed those documents.
Thank you, Judge.
All right. Mr. Flores, do you have any criminal history?
Yes, Your Honor.
And what is his criminal history?
Is minor drug charges.
Okay.
And the DWI that was reduced for which missing officer.
All right. And you're former military?
Yes, Your Honor.
All right, here's the thing. I can accept this plea bargain agreement. It appears to the court that I recognize that he's taken classes, right?
Yes, Judge.
And he's trying to get his life together. I don't know if you can get your life together on your own, right? So I can do one or two things. I can follow this plea bargain agreement. If I follow this plea bargain agreement, you're going to have a felony conviction. And that felony conviction is going to impact your ability for certain government services because it's a felony conviction. So is this your first felony conviction?
Yes, Your Honor.
All right. So what I can do is, one, I can accept this. It's going to be a felony conviction. Whatever governmental assistance that you were previously receiving, it's going to impact this. Laws are being changed, with executive orders and everything that's going on. I don't know if whatever help you're receiving through the government for your military service, if that's going to still exist for you because of this felony conviction. So I can accept this. You'll be done. And that's the good thing, right? You're like, whew, I'm done. Or what I can do is I can accept your plea, not sentence you today. You can see perhaps if you can go to Veterans Treatment Court and see if they will accept you and this not be a felony conviction. So those are things for you to consider.
Judge, we did discuss some of those possibilities, and I believe that he just wants to be done today.
All right. And
Thank
state,
you. Thank you, Judge.
sure. And state, we can go off the record. State, do you all want him to have a felony conviction?
Not especially.
I mean, is that, and here I am being defense attorney and prosecutor, and I know I shouldn't be in that position. But my question is, when I was a prosecutor, I would look at a case, is there enough evidence here to prove beyond a reasonable doubt? And if there is enough evidence to prove it beyond a reasonable doubt, and this is what I always tell people who would sit with me as my second chair, I said, then your next question should be, one, what do you think this person's punishment should be? Do you think they should go to prison? Do you think they should get probation? Do you think they should have a felony conviction? So this case, it's a possession penalty group 2, less than a gram. He's with a vape pen. Can't be using that in the vape. You understand?
Yes, ma'am.
So the question becomes, should this be a felony conviction for him? Because we all know with a felony conviction, he served his country. With a felony conviction, that's going to forestall, if he has mental health, that's going to be a problem with him getting in that because he has a felony conviction. So do y'all really want this to be a felony conviction?
Yes, Your Honor.
No, I'm asking the parties.
From the state's perspective, not especially. However, Mr. Flores, through his counsel, has not indicated any desire to be on any sort of community supervision that would eliminate the immediate possibility.
Well, how many times have I taken misdemeanor pleas here?
I don't believe that a misdemeanor plea is appropriate in this circumstance, Judge, considering the number of drug charges that he has already incurred.
I'm just asking the court to follow the plea.
All right, I'll follow it.
Thank you, Judge.
Thank you, Your Honor.
Sure. All right, thank you. All right, the court is going to find you guilty, sentence you to 200 days, Bexar County Jail under 1244. Give you credit for any time served. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. I appreciate you taking the classes that you were able to take while you were in custody. When you are released, you're gonna have to maintain that, because otherwise you're gonna be back here with another prosecutor, perhaps with another judge, and who knows what will happen. You understand?
Yes, Your Honor.
There are plenty of places, free places that can help you with your drug addiction. If you can't find a place, when you get out, you can come back here. I will pick up the phone, call somebody to help you, okay?
Yes, Your Honor. Thank you.
All right, good luck to you.
Thank you very much.
Thank you.
Put all your phones away.
Okay. And what page is Jodie Flores on?
Judge, may I be excused?
Yes, good seeing you. All right, thank you. All right, could I see the parties on Washington? All right, who's here on Isidro Garcia? They're not ready. Who's here on Daniel Berlanga? The attorney?
Morales.
Hmm? All right, they're not ready. Who is here on Daniel Morales?
Oh, we are not.
All right. Where is he?
I think he's in custody.
All right. And are there applications on these cases?
Yes, Your Honor.
The United States opposed.
All right, probation, these are applications, state is opposed. All right, Mr. Morales, come on down. Court is calling 2025 CR 0022681 and 2025 0022683 State versus Daniel Morales. Can I have parties announce?
Rick Fania for the state of Texas.
Trying to go Simmons for defense.
And are you Mr. Morales?
Yes, Your Honor.
All right, and each of the cause numbers, did you review the documents entitled application for deferred adjudication? With your attorney, did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all of the discovery in each case and reviewed it with your client?
Yes, Your Honor.
And each case will find that the state is in compliance with discovery. Mr. Morales, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
No, Your Honor, but the defendant already entered a plea to this. We're here for his PSI today.
Oh,
Yes, Your Honor. Sentencing only, Judge.
okay, thank you. You have me going through all of this.
I'm
You
sorry.
know, stop.
Stopped you soon.
Bashan, in the words of Representative Lewis, speak up, speak out. All right. To both of them. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. Cases will run concurrently. State is taking in consideration 2025 CR 002-680. There's an affirmative finding of family violence and no contact with the complainant. Are there any witnesses from either side?
None from the state.
We have three, Your Honor, but they'll be brief.
All right, call your first witness.
At this time, I'd like to call Mrs. Morales.
Hello. Good morning. Good morning. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right. Defense, you may proceed.
Thank you. Good morning, Ms. Morales. Thank you for being here. How do you know Daniel Morales, the defendant in this case?
He's my grandson.
And how long have you been on?
Oh, his life.
Okay. And in terms of Mr. Morales, just if you could give the court a brief synopsis of his upbringings and some of the challenges that he has had bringing to that he's had in his past.
Well, to begin with, Daniel, I adopted my grandchildren. And I raised
Speak up just a little bit.
I raised my grandchildren, I adopted them, and I did the best that I could. And they're good kids, they make mistakes, but I'm there with them, and Daniel, because of what they were going through when they were younger, they had no issues. But I did get help for them when they were young, and when they went to school. He didn't get to graduate because he ended up having a child, but other than that, I can say that he tries really hard. When he does work, he's a good worker. He does help out a lot at home. He helps his children with his little boy. And I know that he needs to be there for his son.
Well, you mentioned some of the issues that he had when he was younger, without giving again a whole synopsis, but what are some of the things that you think would stand out? Well, actually, let me back up. Would you say one of the issues is that his mother wasn't there?
Yeah, she wasn't there.
And not to put, because I met her, she's also recovering, is that correct?
Yes.
And but her not being there, what impact do you think that had on her?
It was really hard, the effect that she had.
Okay. And do you think there may have been some anger kind of associated with that?
I think so, yes.
Okay. But overall, you say that but when he does work, he is working. He's working when I first met him.
Yes, when he works, he's a good worker.
And would you say that an issue for him tend to arise when there isn't a lack of structure in his life?
Yes, sometimes, just depending on like who keeps along.
And following up on what you're saying with the things, people that he's surrounded by. You had also mentioned that you had adopted you also adopted his brother Ignacio, is that correct?
That's correct.
Is there any particular program that Ignacio, you've seen him interact with over the last year that's had a significant impact in his life?
Yes, there's a program through the San Antonio Christian Church that he's been in. He's been doing really good in that program. And I'm hoping that, that Daniel would.
Well, we'll get to that part. Right now, I want to focus on, again, you have another, it's Ignacio, who would be his older brother.
Yes, he's his older brother.
And my understanding, my conversation with Ignacio, he's been in that program about 9 months at this point.
That's correct.
So now I want to take your attention back to about 10 months ago. Would you say that the Ignacio you see today is not the Ignacio that existed 10 months ago?
No, he did a whole turnaround and he is like, he's very good. I mean, he's a good kid. All the way around.
And like you were saying, they were good kids, but they had some issues that deal with coming up.
Yes, they
But
did.
but specifically, again, you're saying he's different, because what I'm noticing in
Yes.
your demeanor,
He-
in the
yes,
course of
he's-
her,
he's very
is that you're
different.
somewhat shocked
Yes, very
That-
shocked.
that the transformation,
Yes.
that under the leadership of Pastor Fabian, at this actual program, or
Yes.
that it's had in his life.
Yeah, it had a great effect on his life and he's doing really, really good. And I'm very proud of the way that he is doing. He's so different, I mean. I'm still trying to wow, because it has done a great impact on him. And it's
And-
done good.
In your conversations with Daniel, have you sensed, but you've sensed a lot of quote unquote remorse, not just for what he's done to others, but also what he's done to you and to the people who care about them. And that, you've sensed that remorse?
Yes, Daniel, when he does, gets upset or whatever, he's very quick to forgive. He's very, right away, he asks for forgiveness and he's very sorry for whatever reason. But he's a very forgiving.
But you'd agree that his program for his life has not worked for him at this stage, or at this point, because he's standing here in an orange jumpsuit.
Yes,
So you'd agree that we need some new program.
yes.
Is there anything else you'd like to say to the judge today?
I would just like to say that, take into consideration and, give him a second chance. And I know that he will do better. They're my only grandchildren. I had great grandchildren too, but Daniel, like I said, he's very forgiving and he's willing. I know that he's willing to do whatever it takes for him to do a turnaround, just like his brothers.
I'll pass it with you.
Any questions?
Just a few questions, ma'am. You mentioned that you're Daniel's grandmother, correct?
Yes.
So you adopted him,
Yes,
and was he living with you most of his life?
one of his life, yes. All of his life.
Was he living with you last year?
Yes.
Was he living with you this year?
Yes, he had been staying with me on and off.
How has his behavior been while he's been in the home with you?
His behavior has been, like I said, sometimes he'd get upset, but right away, like I said, he realizes when he does something wrong, so he apologizes. He understands.
So has he shown remorse towards you for any type of anger issues he may have had?
No,
No remorse?
I
Okay.
mean, he's been there, he understands and he doesn't get angry, he just, he realizes if I ask him to do something or, or he forgot because he's always, sometimes he would forget, but other than that, he's, he shows, yes, Grandma, I'm really deeply sorry, so
Has he ever been violent towards you?
No.
Ever been violent toward anyone in the family that you've witnessed?
No, Debbie, he's been arguing with, his girlfriend on and off, but just arguing.
Have you witnessed any physical behavior on his behalf?
No.
Okay. Has his mother ever been in his life?
She just recently came back into his life a couple of years.
Okay, so for the most part of his life, was he without his mother?
No, he talks to her, he's giving her a chance to.
So his mother has been in his life up till now, correct?
Yes.
Okay, all right, no further questions. I'll pass it.
Any further questions?
No, Your Honor.
All right, thank you so much for giving me some insight.
Thank you. Have a nice day.
Oh, thank you. I'll call your next witness.
This time if I could call Ignacio Moran.
All right, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
My name is Ignacio Morales Jr.
All right, you may proceed.
Good morning, Mr. Morales. We spoke briefly, but how do you know the defendant?
He is my brother.
Okay. And would you say that y'all have had a close relationship?
Yes, sir.
Would you say that there's been times where in the minds of you and Daniel, pretty much the only people you really had were you, because you were brothers? Would you say that your upbringing was a bit tough?
Yes.
But would you say that that upbringing was an excuse for any type of violent behavior whatsoever on behalf of you, your brother, or anyone else who was raised in similar circumstances?
Well, there are effects in something like that. The things that me and my brother went through were together, and it might have affected the way we've gotten along when we were younger. Other than that, we love each other.
But you'd agree that regardless of anything y'all gone through in your past, and we're gonna talk about the program that you're currently in and its potential impact on your opinions here, okay? But you'd agree that nothing that you've dealt with in your past would justify any violence towards any other human beings on planet Earth at any time.
I'm not sure about that question.
Okay. What I'm saying is do you feel that let's just start this specific to you, right? Under what circumstances do you feel that violence is the proper response to verbal provocations?
No.
Any situation you can think of it?
No.
Okay. Now, you're currently in a program here in Bexar County, is that correct?
Yes, sir.
What's the name of that program?
It's called DSM, Discipleship School of Ministry.
Okay, where's it located?
6131 Days of Law.
How long have you been involved in that particular program?
About 9 months now, going on 10.
If you could give a brief description of the young man who entered that program about 10 months ago. So in other words, I'm talking about who were you when you walked through those doors? If you were going to describe that person in bullet points, no more than 3, how would you describe that individual?
More than 3.
No more than 3.
I was a drug addict. I was addicted to pornography. I had anger problems.
Okay, so drug addict, pornography, anger problems.
Yes, sir.
That's 10 months ago.
Yes, sir.
Today, would you say that you're still struggling with those issues at the level you were 10 months ago?
No, I don't get like urges to watch anything anymore. But because of I'm also in recovery, so I'm still recovering with all the things that I've watched on drugs, But from that time period, I have lots of healing. So So I don't have any drug cravings. I'm a recovery meth addict. I used to smoke weed. But I've been clean for about 9 months now, going on 10. I haven't had any cravings for almost five months, which is pretty crazy. Because that drug is very hard to not have cravings, if that
Gotcha.
makes sense.
Now, let me, and not to just because we're kind of, so I don't want to, but we talked about this before, so. But you had mentioned one of them was anger.
Yes.
Let me back up. This program happens to be a faith-based program. Would that be accurate?
Yes.
And I asked you a question back there, remember? I'd never met you, right? And the question I asked you was, what is a particular, anything you've learned over there as it relates to dealing with quote unquote anger? And you had mentioned a verse in the book of James. You recall that?
Yes.
What verse was that in James that you brought up?
I don't exactly remember the exact where it's at, but I can kind of paraphrase it.
That's how most of us are. Most of us
Yeah.
can't remember specific, just
It talks about being slow to anger, slow to wrath, slow to speak.
And so would you say that those are the type of impacts that are assisting you with any anger that you may have had from your past?
Yes.
Now, I want you to just briefly, as a person who's actually in this program, okay, describe the environment in terms of the people that are there.
So the environment, you're around people who have like a similar background, but it's all like love welcoming. And it's a big transition. But it's all with love and peace. Transitioning to roles, for example, leaders, you have a squad leader, storm leaders, kitchen coordinator, all these things that you have to learn how to submit to. But coming from a background of a recovery addict, all of these things, and just falling in. So a lot of people that come in, some of them are not used to having rules, or staying at other people's houses and not submitting to their rules. So when you come in, it's learning how to have discipline again, self-control, receive correction and rebuke, things like that. Waking up early, hygiene. A lot of people are not used to submitting to taking care of their bodies and themselves and loving themselves. So learning how to read, if you don't already know those things, but hygiene, self-control, lots of healing. So not only was I detoxing from drugs, but I was also detoxing from relationships, people.
And I want to stay focused on the relationships and the people. You mentioned two interesting words, and that was how to deal with correction and rebuke.
Yes.
And would you agree that in your past, you and your brother, based on, basically being abandoned by your mother to a certain degree, we're not getting on her, I've met her, she's a great lady. Grandma had to raise you, correct? But you dealt with a lot of correction and rebuke prior to this program, you just dealt with it the wrong way, would that be correct? Would you also acknowledge that correction and rebuke of certain behaviors are necessary for you to be able to stand here today, the meek, mild, and young man with the phenomenal future that you are?
I believe so.
Do you think that a similar programming would assist your brother, given how well you know your brothers?
I don't know any other programs, but I do know the faith-based program.
Well, I'm just saying this one specifically, the one that we're talking about.
Yes, I believe it would help. And the brothers that I've met, compared to their backgrounds, their testimony is like on seeing their transformation as well, not only as mine, as really like opened my eyes too, you know what I mean? And it showed me that I'm not alone. I might not be the worst person, but I also consider myself that I was the worst person, you know? So I've seen the things that it's done. So
Let me
I
ask you
think-
this, one more question. When I had spoken to you earlier, you had made mention of the fact that you felt that the program some kind of a way was calling you, even in the midst of a serious drug addiction. Just a story, you felt like it was calling you to a moment.
Yes,
Let me ask you this. Do you think that this is one of those moments that it called you to?
Yes.
I'll pass the witness.
All right, state.
Just a few questions. Mr. Morales, you said that the defendant is your brother, correct? Have you lived with them? Have you lived with them for most of your life? When's the last time you lived with them?
Last time I lived with him. Maybe like a year or two ago. Go back and forth.
How has his behavior been as of the last time that you lived together? Towards you and anyone else that was there, in the residence?
Well, if I can sum it up, we're brothers, you know, so a brotherly relationship. He'll tell me things, what he's going through, and ask for advice. And we could relate to, you know, relationship troubles.
Let me ask you this to kind of help you out. Do you feel like you have a good relationship with your brother?
Yes.
You love your brother?
Yes.
Has he ever been violent towards you?
Well, just, you know, he's one of the closest people to me, if that makes sense.
Okay.
So yes, we have had fought before, you know, but
Do you feel he has an anger control issue
towards me.
towards in general?
He might, I used to have one.
All right.
I believe he does.
Do you support your brother?
Yes, sir.
You feel like your grandmother supports your brother?
Yes, sir.
This program that you mentioned, who monitors this program that you're in?
That would be my pastor, and we also have like home directors and other leaders, but mainly Pastor Fabian.
Okay, so Pastor Fabian, he's the one who monitors the program. I know you testified that you're going on your 10th month on this program, because you've been clean at the time, so congratulations with that, but overall, how long is the program?
So phase one, usually that's I think that's about 6 months that you would stay in phase one. So you're not allowed to leave like the property. There's no substance drinking, none of that's allowed. There's rules until there has to be like a behavior change. There has to be some type of progress. There has to be some kind of change, you know, and before you even come in, you have to have a desire to change and a desire to submit under the program and the rules.
Well, I guess what I'm getting at is if you go into this program, how long are you going to be in this program?
So that all depends, depending on the person's condition. So usually the phase one from 9 or 6 months. Phase two, you're allowed to, you're still under rules, still under leaders, but you're allowed to start working.
How many phases are there?
There's 1 and 2.
Does this program that you're going through have any way to deal with anger issues?
I believe so.
Does it have any way to control violent tendencies? To deal with those in the program?
I think so.
Okay. I'll pass the witness.
All right, any further questions?
Just one, Judge. Following up on, do you agree? There's a flyer for the program. One of it says who we are, and it says who we are not, which, and under it saying that who we are, it says that we are a family. Would you agree with that?
Yes, yes,
Would you agree that it also says we are a school? Would you agree with that?
yes, sir.
It says that we are a new start. Would
Yes,
you agree with that?
for sure.
Is that what it has been?
Yes.
And when it says what we are not, it says we are not a homeless shelter. It's not just a place for people to go run and get a roof. That's correct.
Correct.
We are not a halfway house. It's not a place for people that are halfway in and halfway out, which you actually need to be in. Would you agree with that? And would you agree that it is not a rehabilitation home?
The word rehabilitation?
From the perspective of it's not a detox, it's a fully contextualized new beginning with the quote unquote faith-based.
Yes, I believe so.
Faith-based perspective. Would you agree with those things? And in terms of your new start, do you feel like you've had a new start in life?
I believe so.
And do you believe that new start would be helpful for probably the closest person to you in your life, your younger brother?
Knowing my brother, I believe that it would, because how close I am with him.
Thank you. Nothing further.
All right, thank you. Call your next witness.
Oh, yes, sure. At this time, I'd like to call Pastor Fabian. Oh, Pastor Fabian in Bar Rooms.
Hello, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Fabian Ibarra.
All right, defense, you may proceed.
Pastor, thank you for being here this morning. When I spoke with you in the back, I asked you a question. I told you I was gonna go talk to Daniel. Real briefly before we came up here. Remember that?
Yes.
And I said, if there's one thing that you think I should communicate to him, what was that? Right?
Oh.
You remind, okay, and what was your response to that question?
Yes, please forgive me, I know it's not a laughing matter, it's just, but I also, well, not this year particularly, because we were experiencing a lot of changes and transition in our nonprofit. But there's a faith-based storm. The TDCJ has a faith-based storm. It's a 6-month faith-based program that has structure. There's a wake-up time, there's class time. We with Chaplain Sherman there, Chaplain Bugsby, we've covered everything from anger management, strategies for recovery, relapse prevention, biblical studies, hermeneutics, homiletics, 12-step process group. So my response to you was, there's a 6-month faith-based storm in TDCJ, or the same structure on the faith-based storm that we have it here with the DSM. The whole purpose of the DSM is to prevent people from being incarcerated and having to have that sentence weight on them. So that was my response.
So in communicating to the court, the gist of what you had to say was, if the court were to give him that opportunity, he can either do this there's a faith-based dorm in jail, and there's a faith-based dorm up the street from me. I live in the same zip code. Okay, at the DSM, which is this Christian-based ministry. Is that correct?
Yes, sir.
Okay. Now, just in terms of, we've broken up some of that that program there, but would you be willing to, if the court were to actually make a condition of his probation being enrollment in this program and successfully completing it, is that something you'd be willing to accept?
I strongly motion that. He's lacking a father, he's lacking structure, he's lacking to be literally part of a family, and he's lacking competencies in learning how to respond to anger instead of react to anger. And so I would be willing, if the court would grant me permission, take him in. I don't know if I'd be able to adopt him, but I'd be able to confront him and love him and provide for him, protect him, and teach him principles and core values that we teach and prescribe there at the program.
And the emotion that I'm sensing in you is just the fact that bottom line is that, this probably better than me, but I'm a defense attorney. There's these programs all over the place. Some of them work, some of them don't. Okay. It's not my opinion, but it's the community's opinion that this is one that's working.
It's proven results. Everett Hunter came in, 20-year heroin addiction. He's married, works full-time at Oak Hills Church. The students that go to our phase 2 program, they get hired from like Oak Hills Church, other ministries. I have one that came in 2019. His name is Gregory Setmore. He 2019 hardcore drug addict, hardcore gang member. And here we are, 2025. He's going to start his 3rd year after this semester of seminary. And he is the board chair at the ministry, and he was just ordained as a pastor. So there's a lot of transformation. I can go on and and talk to you about the fruit of the program. But yes, I believe there's transformation that can take place. The individual has to have and maintain a desire to change, because once he loses that desire to change, there's nothing we can do to actually do that. He'd have to want to engage, maintain the desire to change, have to have and maintain a willingness to surrender, and the blessing from a group of people. He has to have a support system.
And and there's nothing wrong with obviously seminary or anything like that, but I mean, but you've also have success stories for people in secular jobs.
Sure.
That are doing things outside of the ministry.
Yeah.
And so.
Yeah, and then the other thing is too, I recommend if he does get mandated by the courts there, that's gonna be mandatory, his term to get a GED. And then we have a cohort with the Goodwill for job training. And so he needs to pick up a trade, he needs to learn a trade, and all that stuff can be done during the program, I believe.
Now, it also says you have to, but I want to just look at the schedule real quick, like for stage 1, right? So in the morning, they have to be up at 7 a.m., correct?
6:45.
6:45, I'm sorry. And if let's say one day he rolls out of bed and you say he needs to be up at 6:45 a.m. and he looks at you and says, I'll see you at 9 a.m. What happens?
There's reprimands, there's disciplinary action. We're not gonna scream I'm not gonna scream at him, I'm not gonna yell at him, there's reprimands. We have things, we just covered this last month at our board of directors meeting, there's the rock pile. You wanna throw rocks, okay, you wanna dig holes, there's all that good stuff, but yeah, so for the tough, we can be tough, for the gentle, we can be gentle. We can become all things to everybody for the sake of winning them over, but yeah, there's a regimen that we follow.
Would he be allowed to leave the campus?
No, not on phase 1. Phase 1, you're not allowed to leave the premises. There's on-campus visits on Sundays. Phone use is permitted. There's no cell phones. There's no baby mama visits. There's none of that stuff. It's all supervised. On Sundays, there's on-campus visits between 1 and 5. Yeah, between 1 and 5 or 2 and 6.
Now, without giving just a full synopsis, but we had talked about this. We said you helped over 100 people. But what would you say is just one of the things that you're able to facilitate as it relates to an enhanced ability to deal with anger?
Dr. Christian Conte, he's one of the ones that covers anger management. Anger management is covered. We have a licensed counselor that comes in once a week to meet with the students. And we also have a 12-step recovery it's covered. Some of our board of directors, like Dr. Jeffrey Buck, he does celebrity care. So if you have to be under a doctor's care.
And when you say celebrity care, what do you mean by celebrity care?
It's a separate, that's his own personal practice. But he has the licensing to be able to cover, like if he needs to be on the Center for Healthcare Services, or if he still needs to be on certain medications that he's currently on, he would be under a doctor's care that sits on our board of directors. Yeah.
What else at this moment do you think the judge would need to hear? And I would ask without objection from the other side. They do have some materials. I don't know if the court wants to review those. This is just from the program. It's the schedule I was just going over is in there. Brief overview of it.
If your honor wants to review it, oh, no, this might.
I'm just asking what the court would like to look at it.
Thank you.
Yes, sir. Well, is there anything else that you think the judge would need to hear? Well, let me back up. So you would be willing if she mandated it, actually you welcome it?
Yes, the last thing I'd like to say is that, yeah, I'd welcome it. He needs to be part of a family, he needs to be restructured. And he needs to understand that if, like earlier, I heard you advocating for somebody else and that's God's grace over your life. But he needs to understand that if the judge is advocating, of the attorney, people are coming in to bear witness of this transition, that if there's a breach, well, then we need to come back to the courtroom and follow up on whatever has to be done because of a breach of the terms and conditions. He can't say he hasn't been loved. He can't say he hasn't tried. He can't say there's no room for error. It's just whatever sentencing has to take place after, if there is a breach. But I'm confident that there won't be a breach contract. If you permit.
I'll pass the lead.
Yes.
Yeah.
Morning, Pastor. Do you know the defendant, Mr. Daniel Morales?
I've known him, I met him last year and I confronted him, I walked up to him, he's pretty tall.
So you're going on for less than a year?
Probably, last time I saw him was, maybe August or September. Something like that. Yeah, it was an outreach, because we do outreach, from 12 to 3. We partner with Corazon Ministries and other nonprofits to go to our outreach. But I walked up to him, I confronted him, I said, you know what, God's gonna use me in your life, and I don't know how it's gonna happen. I didn't think it was gonna happen like this.
So you're unaware of his behavior other than just that brief encounter?
Yeah, he's come to a couple of the prayer groups. He's shown an interest, like a drawing. But outside of that, no.
Alright, so this program that you've been talking about, what's the accountability for people that mess up along the way? Is there accountability?
Oh, yes, sir. There's reprimands, there's disciplinary action, extra detail.
What kind of disciplinary actions are there?
Kitchen detail. There's a zero tolerance for fighting, I'll tell you that. So if he lays hands on somebody, that's termination from the program.
Okay.
Yeah, we do random UAs.
How long is the program?
The program, and it's a minimum of 6 months, but it could be a maximum from 6 to 9 months for phase 1.
And how long is phase 2?
Phase 2 would be about the same thing. They do the first 90 days. The first 90 days is almost equivalent to like faith-based sober living. And then they have to renew it because in phase 2, they have to show proof of employment. They have to show proof of their saving income. There's paperwork that they have to fill out. They have to make weekly meetings, chores and community service hours that they have to do as part of their condition for going phase 2. So it could be its first 90 days. But within the first 90 days, they're not showing improvement. That means they got comfortable and they're sitting on the edge, getting ready to be dismissed. So they can be dismissed in phase 2.
All right. Does it have an anger management component to the program?
Yes, it does.
Does it have any type of component to deal with people that have violent tendencies?
Yes.
Okay. Pastor Wendy Schreiner.
Oh, yes.
All right, any further questions?
I should have spoke this way, sorry.
No, Your Honor.
All right, thank you.
I should have spoken that way.
Oh, that's okay. No, I could hear.
Okay.
Thank you. All right, call your next witness.
Your Honor, this sounds like Daniel Morales.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Daniel Morales.
All right, in just one moment. Is the interpreter ready?
I'm ready, Your Honor.
With the interpreter?
Yes.
Yes.
All right, and we're off the record, and what is your case about?
Ezekiel Chavez, it's 6 months to do no application.
All right, I'm so sorry. Let me finish this hearing and then I'll take you up next.
We're ready.
All right, thank you.
Judge.
Yes,
Um,
we're back on the record.
Mr. Morales, you've heard all of the testimony prior to this, correct?
Yes, sir.
And you've had that discussion about the need for structure, correct?
Yes, sir.
But you recognize that if this judge were to look kindly on the probation application, that none of that would matter if you do not have a desire for change.
Yes, sir. I understand.
And are you asking the court to grant you probation?
Yes, I am.
And if granted probation, do you understand that there's a multitude of things that you could do that could get you sent to jail for up to 20 years?
Yes, sir. I understand.
You also understand that we know it was a back and forth with the alleged victim. Okay, correct?
Yes, sir.
But you understand that there's no more contact with that person.
There's no more contact.
Y'all don't have any children together?
No.
But you do have a child.
Yes, sir.
And part of when your grandmother, when I was talking to her, but also on your urging, a lot of this is because you don't want your son to be dealing with what you're dealing with right now, correct?
Yes, sir.
But you recognize that you need to actually have some training and accountability to get you to a place where your child can inherit your recovery.
Yes, sir.
So last question I would have for you is, what does surrender mean to you?
I think surrender, what to me, I think it means change.
You're willing to give up these past ways of reacting to situations you don't like.
Yes, sir.
And you're willing to accept instructions on how to respond to things you may or may not like, correct?
Yeah, I'm willing to change so I can do better for myself, not only for myself, for my son.
I will pass it.
All right, you may proceed.
Mr. Morales, how old is your son?
He's 4, about to be 5.
Okay. When your son grows up, if he gets involved in an altercation where he assaults his girlfriend, for example, do you feel like he should be held accountable for doing so? What about if it's his mother? If he assaulted his mother, you think he should be held accountable? Do you think if he threatens someone's life, you think he should be held accountable? I'll pass the witness, Ryan.
Any further questions?
Nothing further, Judges.
I have a few questions. Any objections?
No objection from the state.
All right. So,
And but for current judge, we would, in terms of the stipulations that we had tendered to the court, probably should have done this before. Believe those are the same steps that we signed previously with the amendments that we had. Okay.
all right. So this is my concern and what I'm looking at. You have a case from September 16, 2024 with this complainant. And that's pointing a deadly weapon at her, namely a knife. And then you have a case from December 8, 2024. And that's another assaultive behavior against the same complainant, and this time choking her. And all of this is over your breakfast not having ketchup. So number one, what breakfast that you wanted did not have ketchup? This is just for me to know.
The only reason why I brought that up is because I was getting cheated on, and
No. So here's the thing. When people cheat on people, you have two choices. One, you forgive them and expect that they're accept that they're cheating on you. And if they deny it, you either say, okay, they've denied it, I'm gonna let it go. But your choices are either you stay and you accept it or you move on. So back to this ketchup business. So what breakfast were you having that you were so upset that there was no ketchup?
she was upset she didn't have any, and I told her.
No, this is what, let me just tell you what the steps read. It says they spoke to the complainant. The complainant stated that they had been arguing since last night. You struck her on the face. And let me see, where is it? Where you told her to let that BAN get ketchup for her.
Yes.
So this was over ketchup. And it was you who wanted the ketchup.
No,
It says that you wanted ketchup. So what breakfast, was this eggs? It says the complainant stated today they argued because she made breakfast and they did not have ketchup.
I don't eat ketchup with my eggs. She does. And she told me that she didn't have any, so I told her to tell him to go buy it for her.
Yeah. And so how does this turn into you grabbing a knife?
Because she has people knocking at her door, and I couldn't defend myself.
Okay, so that's in September. So you grab a knife in September because you can't defend yourself because she has people in whatever category you're talking about. So then the question becomes, if you think she's cheating in September and you're telling her to tell some other guy to get some ketchup for her eggs, and you pull a knife on her because you're afraid of other people she has, then why are you with her in December?
Because when I got out, she told me that she wanted to take me back. And
But no, why would you want to go back? She's cheating on you. She has these other people in some category that you're afraid of, and you have to pull a knife on her. So why would you even go back to her?
because she told me it was just a sugar daddy that is just some old guy who gives her money. I believe her. And
So then we come to the December case. And the December case involves choking. And it says that that she didn't immediately report because you're controlling and overhear her conversations and read her text messages. So it says that she contacted the babysitter to see if the babysitter could come by. And when the babysitter came by, she let the babysitter know what was going on. So I'm assuming this complainant you were with has children.
yes, she has children.
And when you say children, how many children?
She has 2, a daughter and a son.
And what are their ages?
I think her daughter was 2 and her son was 6.
2 and 6?
Yes.
All right, so you all are having these children see violence in the household, 2 and 6, you think she's cheating? She says she's not. Then she tells you it's a sugar daddy and you're okay with that, which means you're okay with her doing whatever she does to get money, according to you, from a sugar daddy. And where was your child in all of this? This child that now you need to be there for and you want them to see different things. Where were they?
I was still seeing him every day, and she didn't like it because she thought I was talking to the mother of my child.
And that's the other thing. Why would you be with somebody who you think is cheating on you, who has friends in categories that you feel you have to defend yourself with a knife by placing a knife on her, who then tells you it's a sugar daddy, and to top it all off, she really doesn't want you around your own child? Why would you be with that person?
Because I made a mistake, and
Nope, these are choices. These are not mistakes.
yes, it was my choice, and my choice turned into a mistake.
All right. And what's with this tattoo on the face?
It used to say her name, but I covered it up to my brother who passed away.
All right. So, and then you get her name tatted on your face. So you get her name tatted on your face. Don't even have your son's name tatted on your face.
No, I have it all.
As a side note, this is what I always tell people. When you're getting tattoos of people's names, these are your best options. Your mother, because your mother's supposed to always love you, and your children. Getting names of females or males, never a good idea. And what's with this San Antonio tattoo? Do you love San Antonio that much that you need that tattoo? What's that about?
I was born here.
Oh, a lot of people are born here, but they don't have a San Antonio. How many people are born here in were you born in, do you have a San Antonio tattoo?
I don't either, Judge.
So what's that really
I love
about?
San Antonio.
I recently started getting tattoos, so I like how tattoos are.
And then it says 210.
Yes.
Yeah, what's going on with the tattoo?
Like I said, it's just where I'm from.
All righty. Is that your story? You know, you stick to your story.
Yes, ma'am.
What's that tattoo about?
Like I said, it's just where I'm from.
Well, I don't know if I may.
Oh, no. You can ask whatever questions you want to ask counsel.
The environment in which you were raised, I think you probably get to what the court may be alluding to.
Look, are you a gang member?
No.
So why do you have that tattoo?
And if I could.
Sure.
And if you did, if it would be more along the lines of like thousands of people in San Antonio are posers. For example, there's thousands of people in San Antonio who unknowingly have, for example, the Michael Jordan Jumpman design on their arms because they think it's cool around other people, not understanding what connotation that has with actual gang members who are danger to this society and probably shouldn't be here. You understand that, but as basically a kid, how old were you when you got this tattoo?
I got it about a year ago.
Okay, so how old were you?
I was 21.
Okay, so as a 21-year-old, not fully understanding the ramifications of certain things, you personally just thought it was cool. It had nothing to do with you being a gang member.
No, I just got it because I started getting tattoos.
Okay.
Any other questions?
Stay just argument.
All right. All right. In each of the cases, the court does, I don't think you're a good candidate for probation. Unless the complainant is going to walk in here and says that she wants you to have probation, it's not happening. I'm going to find you guilty in each cause number. You all have.
Your Honor, were we able to make the argument or support just?
I'm finding him guilty. You all can make an argument as it relates to the cap. All right, so it's a cap of 5. The court will hear argument.
In support of Kappa 5, Your Honor, the defendant has a long violent history. Essentially, since 2020, he's picked up violent offenses. In 2020, he got a cleansing assault. I was unable, since it's a city offense, to determine the facts of it, but I do know that he served 5 months deferred. In 2021, he had a misdemeanor, ABI family violence, that he did an 8-day JSAT on. The following year, 2022, he picks up another Class C assault that he does 5 months probation on. 2023, a terroristic threat, family violence, that he does 8 months deferred adjudication on. And then these two, all within the same year that we're here for today. There are actually 3 cases, one's being TIC as part of the plea, but I feel that because of this defendant's long violent history, he is not a candidate for probation and that prison would be the most appropriate option.
All right, defense.
Your Honor, we would ask the court to consider the lower end of the cap on this case, which is 2 years. He's expressed a lot of contrition. Of course, in these cases, there are always, but what we would say in terms of the complainant, we guess we would renew this motion to the court. My understanding is that the state, that the complainant has moved out of state and that we weren't here. So if the court would give us time to possibly get an investigator to try to bring her in, or at least see if she has an issue with probation, we would ask the court's leave to possibly do so with the reset. But if the court is not so inclined to allow for the state to try to reach her, or for us to reach her, we would ask the court to come in on the lower end of the range here. He understands that there are things he could have done differently. We're also very, very careful in making sure that we're not blaming the quote unquote victim in any way in these situations. But what we will say is that she was a much older than the defendant. There was a significant amount of manipulation, but again, which is why we presented that evidence to the court. We believe that he didn't have the background to be able to develop the ability to react in a way that would be within the guise of the law, as opposed to ways that could be construed as criminal offenses. Given his age, given the support structure that he has, we would ask the court to come in we would ask the court to give him a sentence of 2 years on this case. And we would also ask the court if the court would be willing to maintain jurisdiction over the case if the court were inclined to give him anything over 2 years.
All right. And each cause number, the court, as previously stated, is finding you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence in each cause number. There should be no contact with the complainant. Taking consideration 2025 CR 002680. There should be no unsupervised contact with minors. There should be no residing with any household that has minors. And our request the therapeutic community in each cause number. In each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, because these are plea bargain agreements, because I followed your plea bargain agreements, because you waive your right to appeal, you do not have your court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Counsel, I'll retain jurisdiction. We'll see how he does.
Yes, sir.
All right, thank you. Good luck to you.
Thank you.
Who is here on the?
Excuse me.
Yes, thank you. Who's here with the interpreter?
Chavez.
Ready, Your Honor.
All right, court is calling 2025 CR 000406 State versus Ezekiel Chavez. Can I have parties announced for the record? State.
Jason Garrett here for State. I'm out on behalf of Ezekiel Garcia Chavez. Ready, Your Honor.
And are you Mr. Chavez?
Yes.
All right, we have an interpreter here today. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right, counsel, do you speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to explain all of these documents to your client in Spanish?
Yes, Your Honor.
And counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Chavez, all of the documents I'm reviewing with you are in English. Were those documents explained to you in Spanish?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, Mr. Chavez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with terroristic threat against a peace officer or judge as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you understand?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Chavez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
And are you a U.S. citizen?
No. No.
And for the record, this is cause number 2025 CR 000406. Counsel, with regards to his citizenship, has an attorney spoken to him about the impact this plea will have on his immigration status?
Yes, Sean, if I may briefly, we requested the MAC office contact him. Justin Tullius did meet with him. He provided me an updated status report as to his immigration status. I've conveyed to him that there is a high likelihood he will get deported, as well as if once he's deported, he may be denied reentry. Knowing all that, he is ready to proceed.
All right, Mr. Chavez, do you understand by entering into this plea agreement, you will be deported and are not allowed reentry into the United States?
Yes.
Knowing that, do you still wish to continue with this plea?
Yes.
And do you understand that you will also be denied naturalization?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 180 days in the state jail facility. There are no applications. The state will take in consideration 2025 CR 000405. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He just wants the court to know that he does accept responsibility.
All right, the court, as previously stated, is finding you guilty. The court will sentence you to 180 days in the state jail facility, give you credit for any time served. Take in consideration 2025 CR 0004005. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Thank you.
Yes.
And I believe the dismissal form is here. Do you want that, Judge?
Yes. Thank you.
Thank you. Excuse me, Your Honor.
Yes. Who's here on Constance Sinwell? All right, so do you have all discovery?
Judge, no. We do, I conferred with the state today, Garcia is in, but apparently there's this program that needs to be uploaded to see it, and I gotta do that at the DA's office. The prosecutor here is not sure how to do that either, so we're gonna meet with.
One of the prosecutors,
Okay, we're gonna meet with someone in the office who knows how to download it, and they still haven't got the medical records, which they've now subpoenaed twice.
All right, so what I'm gonna do is I'm gonna reset this for May 19th, and we're gonna make sure that everything is given over.
I appreciate that.
All right, Ms. Ferguson on Sinwell, May 19th, final discovery.
I'll let the state know so we can try to.
All right, thank you. Thank you. Who's here on Jose Mahia?
No.
All right, where's Mahia?
He's coming, Judge.
All right, so today, discovery and offer due. Do we have all discovery?
Yes, Judge. We've turned in a discovery agreement.
All right. And has an offer been tendered?
It has.
Okay. How much time are you requesting defense for a plea deadline date?
60 days,
I'll give you 30.
45,
I'll give you 35.
35.
All right, Ms. Ferguson, recall this in 35 days for a plea deadline date, please.
June the 9th, okay?
All right, we'll see you back on June 9th. Sir, on June 9th, you need to let the court know whether or not you've accepted an offer with the state. If you have not reached an agreement, then your next court date will be a jury trial date, and the court will only accept a plea bargain agreement with good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you. Thank you. Who's here on Tomminique Grant? Where are we on this case?
Okay, so today I think we're set for discovery hearing,
Mhm.
and I think we're in pretty good shape on discovery.
Okay.
We have conferred, and I guess probably we'll need a plea deadline and trial setting. I have a motion to suppress. I'll keep filing.
All
But
right.
the other thing is that we had appeared, I think, on a bond reduction that I hadn't filed yet last time. The court asked for some follow-up information.
Yeah.
I did file it this morning. But we have the bond set at 75,000. We're asking for a reduction to 40,000. And with conditions of DPS and to go directly we're trying to find a place for him, either a Salvation Army 180-day residential men's program or Haven for Hope.
All right, so let's do this.
Okay.
Your Honor,
Because-
Your Honor,
Yes.
can I speak please before you
Sure.
make this decision, Your Honor?
Mhm.
This is what my teachers on what I'm asking the court, Your Honor. I have mental issues like I spoke with you the last time,
Hold on.
the bar reduction, I'm not talking about. the
Okay,
case.
all right.
Okay, so let me explain something to you. All right, so before you even say anything, because this may address the entire issue. Number one, my concern, and I noted it, that there's maybe some mental health.
Yes,
Then we have an issue with he has no place to stay.
correct.
So those are the court's two concerns. Your
Right.
attorney has just said that she's looking into some certain places where maybe you can stay. What I can tell you is, it is best for you that she has the information. Yes, he can stay here or he can stay there. Because putting you on GPS, guess what? They're not gonna let you have GPS if you don't have a place to stay.
No, that's not what I'm saying. You was hitting the nose from the beginning. This is what I'm saying. It's pertaining to my place to stay or what I'm asking the courts. If it's possible, instead of giving me a bond reduction, could you take this into consideration as placing me as, because one of the places that my social worker got with me on was the Salvation Army because they have a mental program. And I would like to, since I'm a candidate for it, I would like to be a full participant in that until pending trial or whatever situation is, to where I will have a place to stay, I will have my mental issues taken care of at the same time. I'm not asking to get out on bond to roam freely. I'm asking.
No, I understand
I'm
that.
asking
So
for
what you're
help.
asking the court is not for a reduction, you're asking for a PR bond?
Something, but this, I want to get placed in the facility to where I can receive treatment because of my mental issues, and like I told you the last. That's all I'm asking the
All
court.
right, so this is
please.
what I want you to do. I want you to internalize what I'm saying, because I think we may be saying the same thing, but we're just crossing each
Yeah, but
other.
I just don't want you to think that I just want to get a bond reduction to get out on the GPS monitor. I'm asking the courts for help on a mental state.
No, and what I'm telling you is, that's what I'm trying to do, and that's what your attorney is telling me. So you're saying you may have placement, a place to stay. Well, I'm gonna need verification of that, and your attorney says that she's gonna give me the verification of that, if that's the case. So what I'm gonna do, counsel, if I'm gonna reset this for a plea deadline date.
Okay,
But if you have a place for him to stay, if you have that available tomorrow, just come back to court. We'll have a hearing. They'll have him brought over tomorrow.
okay.
So-
The logistics of it is where we kind of get snagged up because it's like, well, he has to get released on bond first and then we can make arrangements, it's.
Oh, no, I think if you can get somebody here from the Salvation Army, I think we can work on that. So,
Okay.
and they can appear by Zoom.
Okay,
So what I'm gonna do is, I'm gonna set this, and I want you to hear what I'm saying, okay? So your plea deadline date is gonna be May 29th.
I'll be out of town that day,
Oh.
any other day. That week I'll be gone, but.
Oh, okay. Do you want to do it? Otherwise, I'd have to put you in June. Are you okay with June then?
Yes, or I don't mind coming earlier.
I can put you then for May 22nd.
I can do that.
All right, Ms. Ferguson, plea deadline date is May 22nd. So that's your plea deadline date. Now, this issue with your bond and your residency, your attorney can come back any day.
I know you
If she
said
got-
that the last time.
Yes,
I'm-
so-
I don't mean to cut you short,
Yeah.
cause she didn't fully get it understood, cause I heard exactly what you said the last time
Mhm.
about when you came the first time with the
Uh-huh.
bond reduction thing. I just wanted to get it understood that she said, when you say anytime, literally, you mean anytime, literally?
No, not literally. It has
Yeah.
to be coordinated with the court
That's what I'm saying.
coordinator and the court. No, it's not. I can't just walk in.
No.
No.
So what will end up happening, for example, is she's able to call them today and they say, yes, we have a place for him to stay, then all she has to do is contact the coordinator and say, can I come back for tomorrow? Or can I come back on Wednesday or Thursday or whatever day it is? We'll set it, we'll bring you back and she'll have the information for you. So it'll be before the deadline, the plea deadline date, okay? All right. Do you have any questions?
Cause the thing is, ma'am, I'm just trying to get help, treatment until we formally resolve this situation dealing with this criminal case, ma'am. That's all I'm asking is for help.
No, I understand, and we're trying to do that, but part of my job as a judge is also to make sure that the community is protected and make sure that you get what you need, your treatment. And so she's trying to make sure that she verifies that there's a place. If she can get a hold of your case manager and the Salvation Army, well,
It's someone from MAG, Your Honor, it's not an independent case.
okay, so
But
if they,
it's just the logistics of it, and because funding has shifted and things have shifted, it's gotten a little harder to figure out, but, and the wait lists are longer.
okay,
Okay, we'll get that information together. She went back to her office to try to get some more substantive detail.
all right, thank you.
Okay, thank you, Judge.
You're welcome. Who's here on Christian Allen Garcia?
Sorry, Judge, I had some other cases up. I didn't expect him to come first.
All right, so do you have all the discovery?
We don't, Judge. That's the reason we've been getting rescheduled. What
All right.
happened is there's a juvenile that was charged with some offenses, my client. We're trying to get the files on, and as you know, those files are in another department. They're not readily accessible to me. There are several aggravated robberies. I'm trying to.
Oh, just 1 second.
I'll let him finish, but I just need to step away to speak with
Sure.
Mr. Garrett.
And so, because the juvenile had so many cases, the juvenile, they actually resolved his matters without taking into consideration the cases my client has pending in your court. So we're trying to recover, where's the discovery on those cases, so that I can have access to them.
And who is the juvenile? Is that the co-defendant
The
or?
co-defendant, yes, Judge. We would suggest the main actor in the case.
Okay,
Judge, so regarding the juvenile co-defendant, we reached out to the juvenile division of our office. They represented to us that because the juvenile also had a large amount of cases, that they worked out cases that were actually charged in the case at the time when they reached the plea deal. The cases that are involving this defendant were not actually formally charged, and they never received any evidence for them, and they were resolved with the plea deal. And so there's no additional evidence at juvenile pending.
Well, Judge, that doesn't mean they don't exist. In fact, the state's suggesting that the investigating officers just gave up working on the files and never submitted them. They'll tell us that, that's fine, but I still want that evidence.
What evidence specifically are you requesting? Because they wouldn't have just ceased investigating it, they would have turned it in under this defendant's case. So if you
Well-
point to something specific that you need, I can reach out to them, but just saying a blanket whenever you turned over everything that I have is just not feasible.
Well, and I understand that, Judge, and I'm not trying to be difficult, but this juvenile was charged with over 10 aggravated robberies, maybe as many as 15 or 20. Right? He's a serial aggravated robber. My client was only charged in one day. And we believe we may be able to raise an arrest defense and other things like that. So the big picture of what happened with that juvenile and what he was up to and what he did would be very enlightening for the jury. And it could be even exculpatory in terms of me being able to prepare my arrest defense.
all right, so who is the prosecutor who handled that case? And is that the person you're reaching out to, that prosecutor?
We reached out to the investigator and the prosecutor. I think. You just give us a.
Sure.
I would have, Judge, I'm sorry, it's been a while since
No,
I
no.
contacted them, but I'd have to check my emails real quick.
All right.
If I may.
And the reason why I'm asking, because then this is what I suggest we do. If that prosecutor is over in juvenile, still in juvenile, then of course they can't be here. They can appear by Zoom. So we can get to the bottom of the discovery and what they have. So I'm gonna give you all another set date for discovery. And if that prosecutor, whoever they are, if they are in still in juvenile, you know, they have to be over there. That's on probate. See if they can Zoom in, and then we can find out what discovery they have, what they don't have, and who touched the file, who did not touch the file. All right?
Yes, Your Honor.
All right, so do you all think there's enough time if I set it for May 27th or May 29th?
That should be sufficient. whichever day
Either
works
one?
for-
May 27th or May 29th?
That would be great, Judge.
All right, Norma, this is coming back for May 29th.
Judge, I have another motion on Mr. Garcia, if I may.
What is that motion?
One of his charges is evading in a vehicle. He has a condition of no driving.
Mhm.
It's been a year since the offense date. He's been in full compliance with the court's orders. It's becoming difficult for him to get to work and do the things kind of he needs to do with his parents constantly having to chauffeur him around. And they're here today also to testify about what the essential need is. But basically, he wants the no driving restriction removed, at least enough for him to go to work and come back home.
State, do you have objections to him being allowed to drive to and from work?
Judge, if I could just have a minute to.
Sure. After this case, it's going to be Washington, Galvon, Altimarino, and Moore, and Rivera.
Can you sneak in Berlanga too?
Huh?
Can you sneak in Berlanga too?
I don't know if it's up here. If it's up here.
Actually, it was the first one I asked her this morning.
Okay.
He must have got second wrong.
Judge, so I don't necessarily have an objection to him being able to drive because there's been no pretrial violations, but I just would request a curfew.
All right, so if you all figure out what the curfew will be, and I'll allow him to be able to drive to and from work.
Okay, Judge, I'll work on that order while I step back and I'll bring it back.
All right, thank you.
I excuse my client.
Yes, well, once he signs the reset form. All right, on Washington. Good morning. All right. So my understanding, you all have previously entered into a plea, correct?
Yes, Your Honor.
All right, the court is calling 2025 CR 00495 State versus Mason, Washington. Could I have parties announced for the record for the state?
Ashley Jones.
Defense?
Christine McDonald for Mr. Washington.
And are you Mr. Washington?
Yes.
So have you all changed your plea bargain agreement or no?
Your Honor, we have not come to a resolution at this time. I've asked the state to hold the 4 years TDC offer open until the next setting. Like at this time, Your Honor, my client is requesting a trial setting. At our previous hearing, Your Honor, you did grant us funds for an expert. I did tender my copy of a specific request for discovery to the state at that time. I re-forwarded it today. We are still waiting on some additional discovery that our DNA expert is requesting, Judge. But at this time, we did not come to a resolution and are requesting a trial setting, Your Honor.
All right, are you ready for trial?
Your Honor, I'm still working with my expert and they have not disclosed this additional discovery that we discussed last time, Judge. And that might be because we did have a plea worked out, which did not.
All right.
We weren't able to follow through on.
Did you all review the defendant's discovery request?
We did, Your Honor, and I made the request this morning and they have already uploaded what the defense has requested. However, I do know that there's a 24-hour delay on when they can see that information.
All right, so you have no objections to the discovery that's being requested?
Correct, Your Honor.
All right, so the court will grant the discovery request. And this will be set for jury trial. And you said it'll be uploaded when?
It's already uploaded, Your Honor, but there's just a delay. It's actually viewed the material
All right, and when will they be able to?
tomorrow.
Okay.
My understanding.
All right, I'll set this for jury trial on May 13th.
Well, Judge, if we can request a little bit more time so my expert can have a chance to review everything. I did let him know that we'd be getting in contact with him because we were hoping that we had resolved this case, Your Honor. So if I can have time to work with this expert, so he can have enough time to look at everything in the case and give us an informed evaluation.
All right, then we'll come back on June 10th. Norma, set this June 10th for jury trial. All right, thank you.
Thank you, Your Honor.
All right, you're welcome. Yes.
I forgot to give this to you, this was on that again, when I was
Thank you.
PSI, the case that was TSC.
Here you are.
Thank you.
You're welcome. All right, who is here on Camillus Galvan? All righty. Who is here on Guillermo Altimarino? All right. Court is calling 2024 CR 011696 State versus Guillermo Altimarino. Could I have parties announced?
Andrew Harris, State and State.
Adriana Biggs for Guillermo Altamirano.
And are you Mr. Altimarino?
Yes, ma'am.
Thank you for dressing appropriately for court. Counsel, you received all discovery. Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there applications in this case?
Yes,
Yes.
Your Honor.
All right. Did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
That's correct.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, reducing this to a Class B misdemeanor DWI.
Any objections?
No, Your Honor.
And Yaya, for some reason, I don't have their application for community supervision. Oh, thank you. Counsel?
Yes, Your Honor.
Thank you. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I do understand.
All right, the state is proceeding on the lesser included offense of driving while intoxicated as Class B misdemeanor. Range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
I do understand.
Counsel, did you intend to do that? Yes or no?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 180 days in the Bexar County Jail. There's a $2,000 fine and the state recommends community supervision. Did you understand that to be the plea?
Yes, I did.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did both.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I do understand.
Counsel, have there been any such motions?
I'm sorry, Your Honor.
Have there been any such motions?
No, Your Honor, they have not.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours community service restitution, 1 year license suspension, and 72 hours in the Bear County Jail. Did you understand those are recommendations from the court, from the state, and the court does not have to follow those recommendations?
I do understand.
Then to the offense of driving while intoxicated as a Class B misdemeanor, how do you plead?
No contest.
State any evidence.
State offers exhibit 1 and attachments.
No objection, Your Honor.
All right, and before I review that, state, do you have any objections to the defendant serving the 72 hours in the Bear County Jail on GPS as opposed to the county jail?
No.
All right.
To the court holding the 72 hours in advance.
All right, thank you. You may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, I do understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I do, Your Honor. Mr. Altamirano is the father of 4 children. Him and his wife had split up. That led to the incident that we're here on today. He is a salesman for a builder. His business has been very slow. He has the children. It's joint custody. They split him 50-50. He pays for their insurance as well. And so I would ask that the court probate that fine. Mr. Altamirano certainly is going to succeed. There's no doubt in my mind that he's going to succeed, but we would definitely ask for the court's deference in regards to that fine.
All right. And what do you do for a living?
I'm in sales customer service.
And what are you selling?
Selling homes.
Okay. All right, this is what the court is going to do. Court is going to sentence you to 180 days in the Bear County Jail, suspended for 2 years. There's a $2,000 fine that will be probated, 1 year license suspension, 150 hours of community service restitution. Once you completed parenting classes, the court will deem that satisfied. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days, no employment as a home health care provider or with minors. There should be 60 sober meetings in 60 days. Field visits 1 time per month for 3 months. TAP evaluation out of custody. Follow recommendations. Now for this next part, I'm going to give you a choice. 1, I can do ignition interlock on your vehicle, and that ignition interlock will be for 6 months. Or you're gonna have to do the 72 hours in the Bear County Jail. So if you want the ignition interlock, I'll give you the ignition interlock and I'll hold the 72 hours in advance, or you're going into custody today to do your 72 hours.
Okay with the 6 months.
All right. So there's gonna be an ignition interlock for 6 months. And what I will do, I'll hold the 72 hours in the Bear County Jail in abeyance. Probation, is there anything else he needs? Is there anything else you need from the court?
No, not from the defense.
All right, you need anything else from the court?
No, ma'am, thank you.
Thank you. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I do understand.
All right, we can go off the record. Here's the thing. You're one of those people who can't drink. While you're on probation, you're not allowed to drink alcohol. I have yet to have someone come before me and say, you know what? My goal tonight was to go out, get intoxicated, hit somebody, kill somebody. But it always happens, right? You have children. I know you don't want your children being driven around while somebody is out there intoxicated driving. You understand? So do better. All right. Good luck to you. Remain in the court probation. We'll go over conditions with you.
Thank you, Your Honor.
You're welcome. Thank you, Your Honor. You're welcome. Who's here on Mitchell Moore? Court is calling 2025 CR 001524 State versus Mitchell Moore. Can I have parties announced for the record?
Megan Galloway for the state.
Robin Porter for Mr. Moore and Judge, I'd like to clarify a little bit on paperwork.
Yes.
Paperwork has his middle name, that is misspelled middle name.
Okay.
The paperwork, I just want to let the court know it's actually Kiare.
All right. And are you Mr. Moore? Counsel, you received all discovery. Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Moore, did you review the application for community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
No, Your Honor, we move to proceed on the lesser included offense of driving while intoxicated with blood alcohol concentration 0.15 or higher, which is a class A misdemeanor.
Any objection?
No objection, I believe.
All right, everyone, please don't talk behind the court reporter when we're on the record.
No objection, and also waive the count.
All right. All right, Mr. Moore, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of DWI as a class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Moore, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 1 year in the Bexar County Jail. There's a $2,000 fine. The state recommends community supervision. Did you understand that to be the plea?
Oh, yes, ma'am.
Defense, is that the plea?
It is.